Chapter 6. Formal and Essential Requisites. Section 38. Definition of promissory note. A satisfactory definition of a promissory note is found in the Negotiable Instruments Law, which states, "A negotiable promissory note within the meaning of this Act is an unconditional promise in writing made by one person to another, signed by the maker, engaging to pay on demand, or at a fixed or determinable future time, a sum certain in money to order or to bearer. Where a note is drawn to the maker's own order, it is not complete until endorsed by him." Section 39. Definition of bill of exchange. The following is a good definition of a bill of exchange found in the Negotiable Instruments Law. A bill of exchange is an unconditional order in writing addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand, or at a fixed or determinable future time, a sum certain in money to order or to bearer. Bills of exchange are either foreign or inland. Foreign, when drawn in one state or country, and made payable in another state or country. Inland, when drawn, and made payable in the same state or country. For the purpose of the law of negotiable instruments, the several states of the United States are foreign to each other. Thus, a bill drawn in Pittsburgh, Pennsylvania, and payable in Columbus, Ohio, is a foreign bill, while one drawn in Cincinnati, Ohio, and payable in Cleveland, in the same state, is an inland bill of exchange. The Negotiable Instruments Law provides, an inland bill of exchange is a bill which is, or on its face purports to be, both drawn and payable within this state. Any other bill is a foreign bill, unless the contrary appears on the face of the bill. The holder may treat it as an inland bill. Section 40. Formal and Essential Requisites in general. The Negotiable Instruments Law has the following provisions. An instrument to be negotiable must conform to the following requirements. 1. It must be in writings and signed by the maker or drawer. 2. Must contain an unconditional promise or order to pay a sum certainly in money. 3. Must be payable on demand or at a fixed or determinable future time. 4. Must be payable to order or to bearer. 5. Where the instrument is addressed to a drawee, he must be named or otherwise indicated therein with reasonable certainty. There is also another provision in the law providing that, the instrument need not follow the language of this Act, but any terms are sufficient which clearly indicate an intention to conform to the requirements hereof. Section 41. Must be in writing. As pointed out above, the instrument must be in writing. When writing is spoken of, it is not meant merely that which has been written with a pen or pencil. It includes also that which is in print or has been printed. The word instrument implies that which has been reduced to writing. Therefore, the words negotiable instruments themselves indicate that which has been reduced to writing. In order to be negotiable there must be a writing of some kind, else there would be an absence of the thing to be negotiated or passed from hand to hand. The reason a promissory note or bill of exchange must be in writing is clear, that is, the instrument is currency, and could not run on crutches. So the whole of the bill or note must be expressed in writing. If it is complete on its face, the general rule is that no evidence of a verbal agreement made at the time, qualifying its terms, can be admitted. Contemporaneous written agreements are admissible for the purpose of controlling the effect of the instrument as between immediate parties and those having notice. Parole evidence is generally admissible as between the parties, to show their real relations to each other, and if there be a latent ambiguity to explain it. And, in general, parole evidence is admissible between the original parties to show fraud, accident, or mistake in the creation of the instrument, or the failure, entire or partial, of consideration. It has been decided many times that if any discrepancy or ambiguity exists between the figures and the words indicating the amount called for by the instrument, the words are to control. The figures constitute no part of the note or bill, but are inserted merely for convenience of reference. Section 42. As to style and material. The law does not require any particular form or style as to a promissory note or bill of exchange, yet it does not seem that it would be wise to depart from the approved forms in vogue among merchants. The law looks to the substance of the transaction rather than the form, and if the intention of the parties as to assuming the obligation of drawers and makers of negotiable instruments can be determined, the law will give them force and effect regardless of the form. There is no arbitrary rule governing the material upon which the instrument should be written. It may be written upon parchment, cloth, leather or any other substitute for paper. It may be written either with a pencil or with ink. The permanence and security of ink as compared to a writing in pencil makes the ink preferable. Section 43. The date. A date in a bill or note is not necessary. The negotiable instruments law provides that the validity and negotiable character of an instrument are not affected by the fact that it is not dated. It is of no consequence on what portion of the paper a date is written, but it is usually written in the upper right-hand corner of the instrument. If dated, it will be presumed to have been executed on the day it bears date. That is, where the instrument or an acceptance or any endorsement thereon is dated, such date is deemed prima facie to be the true date of the making, drawing, acceptance, or endorsement, as the case may be. If there be no date, it will be considered as dated at the time it was issued, and parole evidence is admissible to show from what time an undated instrument was intended to operate, or, if a date appears, to show that there was a mistake in the date. So an instrument may be antedated or post-dated. The instrument is not invalid for the reason only that it is antedated or post-dated, provided this is not done for an illegal or fraudulent purpose. The person to whom an instrument so dated is delivered acquires the title thereto as of the date of delivery. Where a blank has been left on the instrument for the date, it may in some cases be filled in by the holders. Thus, where an instrument expressed to be payable at a fixed period after date is issued undated, or where the acceptance of an instrument payable at a fixed period after sight is undated, any holder may insert therein the true date of issue or acceptance, and the instrument shall be payable accordingly. The insertion of wrong date does not avoid the instrument in the hands of a subsequent holder in due course, but as to him, the date so inserted is to be regarded as the true date. Section 44. The signature. It is immaterial in what part of the instrument the name appears, whether at the top, in the middle, or at the bottom. Anything from which it will appear that a person intended to make the instrument his own is sufficient. As long as the signature or emblem of the drawee or maker appears anywhere upon the instrument, it is deemed prima facie evidence of his intention to be bound by its obligation. It is immaterial whether the writing is in pencil or ink, although as a matter of permanence and security, ink is, of course, preferable. And the name may be printed or typewritten as well as written, though, in such cases, it cannot prove itself, and must be shown to have been adopted and used by the party as his signature. If another sign the name of the party in his presence and at his request, it is the same as if he did it himself, and if another sign the party's name by verbal or other authority, it is sufficient. The full name may be written, and at least the surname should appear, and generally does. But this is not indispensable. The initials are sufficient, and any mark which the party uses to indicate his intention to bind himself will be as effectual as his signature, whether there be a certificate of witnesses on the instrument or not. And the signature of any party may be made by a duly authorized agent. No particular form of appointment is necessary for this purpose, and the authority of the agent may be established as in other cases of agency. A signature by procuration operates as notice that the agent has but a limited authority to sign, and the principal is bound only in case the agent in so signing acted within the actual limits of his authority. Where a signature is forged or made without the authority of the person whose signature it purports to be, it is wholly inoperative, and no right to retain the instrument, or to give a discharge therefor, or to enforce payment thereof, against any party thereto, can be acquired through or under such signature, unless the party against whom it is sought to enforce such right is precluded from setting up the forgery or want of authority. The negotiable instruments law provides, no person is liable on the instrument whose signature does not appear thereon, except as herein otherwise expressly provided. But one who signs in a trade or assumed name will be liable to the same extent as if he had signed in his own name. Apostrophe. Section 45. Must be promise or order to pay. In order that the instrument contain a promise, it is not necessary to use the word promise. But while it is not necessary to use that particular word, it has been held that the instrument must contain an express promise. The instrument contains an express promise whenever it contains an expression equivalent to the word promise. It has been held that where a certain time for payment has been expressed in the instrument, or the words on demand are used, the instrument contains a promise. Example, due A, B, $76.50 on demand, or pay to A, B, $76.50 on December 24, 1908. The words value received, or to be accountable, do not import, nor are they equivalent to a promise to pay. In a bill of exchange it is no more necessary that the word order should be used than it is that the word promise should be used in a promissory note. Any words which are equivalent to an order or which show the drawer's will that the money should be paid are sufficient to make the instrument a bill of exchange. A bill of exchange is something more than the mere asking of a favor. It is in its very nature an instrument demanding a right. Hence a mere request or supplication made or authority given to pay a certain amount of money has been held not to be a bill. The following would be a good bill: Mr. Smith will much oblige Mr. Jones by paying John Brown, or order, on account $50.00. The words by paying are held sufficient to import an order to pay. Section 46 must be payable to order or bearer. By the negotiable instruments law, bearer means the person in possession of a bill or note which is payable to bearer. However, it is not essential that the words to order or to bearer be used so as to make the instrument negotiable, although they are the simplest words and the ones most frequently used. The words to a holder and to and his assigns are equivalent words which will render the instrument negotiable. These words of negotiability may be dispensed with, and the expression, "this is and shall be negotiable," may be inserted in the instrument, which expression makes the paper fully negotiable. The instrument may also be made negotiable by using the words to the order of A. But if the instrument reads to the bearer, A, it is not negotiable, because the expression, to the bearer, is only descriptive of A, and there are no words of negotiability. The negotiable instruments law sets down certain rules as to when an instrument is held payable to order and also when held payable to bearer. The instrument is payable to order where it is drawn payable to the order of a specified person or to him or to his order. It may be drawn payable to the order of 1. A payee who is not maker, drawer or drawee, or 2. The drawer or maker, or 3. The drawee, or 4. 2 or more payees jointly, or 5. One or some of several payees, or 6. The holder of an office for the time being. Where the instrument is payable to order, the payee must be named or otherwise indicated therein with reasonable certainty. The instrument is payable to bearer, 1. When it is expressed to be so payable, or 2. When it is payable to a person named therein or bearer, or 3. When it is payable to the order of a fictitious or non-existing person, and such fact was known to the person making it so payable, or 4. When the name of the payee does not purport to be the name of any person, or 5. When the only or last endorsement is an endorsement in blank. Section 47 must be certainty as to engagement to pay. If the instrument is a bill, it must contain a certain direction to pay. If it is a note, a certain promise to pay. As stated heretofore, a bill is, in its nature, the demanding of a right, not the mere asking of a favor, and therefore a supplication made or authority given to pay an amount is not a bill. The language, "Pleased to send $10.00 by bearer, as I am so ill I cannot wait upon you," is held not to be a bill. A promissory note must contain a certain promise to pay. If over and above the mere acknowledgment of debt, there may be collected from the words used a promise to pay it, the instrument may be regarded as a promissory note. An instrument is payable on demand. 1. Where it is expressed to be payable on demand, or at sight, or on presentation, or 2. In which no time for payment is expressed. Where an instrument is issued, accepted or endorsed when overdue, it is, as regards the person so issuing, accepting or endorsing it, payable on demand. Section 48 must be certain as to amount. It is also a requisite to the negotiability of an instrument that it shall call for the payment of a definite and certain sum, and not for unliquidated damages. The amount to be paid or the amount which the paper represents should be stated plainly on the face of the instrument, and like the denomination of money must be stated in the body of the instrument or it will be defective, unless it has been left blank and express or implied authority given to fill it up. The amount is customarily written in the margin also, but this is held to be no part of the instrument, and made simply for convenience of reference, and the statement in the body of the instrument controls, and should they vary any holder may change the marginal figures to conform to the amount as written in the body of the paper. Unless required by statute to be written in words, the amount may be stated in the body of the instrument in figures. Abbreviations and characters which have well-defined meanings may be employed. There is some conflict of authority as to whether if they be added to the amount, with exchange, on with current exchange on another place, the commercial character of the paper is or is not impaired. The weight of authority is that it is not, as that is capable of definite ascertainment and so the amount to be added is certain. A stipulation as to interest does not make the amount uncertain. It might be stated here, by way of parenthesis, that it is a general rule of commercial law that where a note is made payable with interest, without specifying the rate, or the time from which the interest is to be computed, the note carries interest from the date of its complete execution or its issue, at a legal rate fixed by law. The provisions in notes, payable in part payment or installments, to the effect that if any one of the installments is not paid as agreed, all installments or the whole sum shall become due and payable, does not destroy the negotiability of the note, and such notes are quite common. The provision that the interest shall be paid at stated intervals, and if not paid the entire sum shall become due, is also common, and does not affect the negotiability of the paper. There is likewise a conflict as to whether by adding the words, with reasonable attorney's fees, the negotiability of an instrument is destroyed. The better opinion is that they do not. Instruments with such words are not like contracts, to pay money and do some other things. They are simply for the payment of a certain sum of money at a certain time, and the additional stipulations as to attorney's fees can never go into effect if the terms of the bill or note are complied with. They are, therefore, incidental and ancillary to the main engagement, intended to assure its performance or to compensate for trouble and expense entailed by its breach. The negotiable instruments law fully covers all such stipulations by providing that the sum payable is a sum certain within the meaning of this Act, although it is to be paid 1. With interest, or 2. By stated installments, or 3. By stated installments, with a provision that upon default in payment of any installment or of interest, the whole shall become due, or 4. With exchange, whether at a fixed rate or at the current rate, or 5. With costs of collection or an attorney's fee, in case payment shall not be made at maturity. Section 49 must be certain as to time of payment. The instrument must be payable without conditions and at all events in order to be negotiable. If the order or promise be payable provided terms mentioned are complied with, as, for instance, that a certain receipt be produced by a certain time, it is not a negotiable bill or note, and likewise if a payable provided a certain ship shall arrive, or provided the maker shall live a certain time, or upon any contingency. An instrument payable upon a contingency is not negotiable, and the happening of the event does not cure a defect. If the time must certainly come, although the particular day is not mentioned, the instrument is regarded as negotiable, as the fact of payment is certain. If the instrument is payable at, on within a certain time after, a man's death, it is sufficient, because the event must occur. An instrument is payable at a determinable future time within the meaning of this Act, which is expressed to be payable 1. At a fixed period, after date or site, or 2. On or before a fixed or determinable future time specified therein, or 3. On or at a fixed period after the occurrence of a specified event which is certain to happen, though the time of happening be uncertain. In a few decisions a note or bill made payable on or before a stated date has been held non-negotiable, but the great majority of decisions declare such an instrument to be negotiable, since the legal rights of the holder are clear and certain, and the instrument being due at a time fixed and not before, the maker has a mere option to pay in advance of the legal liability if he sees fit. If a bill or note is made payable expressly or impliedly out of a particular fund, it is not negotiable according to the law merchant, because there may be no such fund. An unqualified order or promise to pay is unconditional, though coupled with an indication of a particular fund out of which reimbursement is to be made, or a particular account is to be debited with the amount. But an order or promise to pay out of a particular fund is not unconditional. Section 50 must be certain as to place of payment. The purpose of a certain place of payment being set out in the instrument is to fix the place at which the holder must present the bill of exchange or note for payment. This is a very important feature of the instrument when we come to consider the liability of sureties and endorsers. If no place is mentioned, presentment must be made at the place of business of the primary obligor. If he has no place of business, presentment must then be made at his residence. Another purpose of having a certain place of payment set out in the instrument is to determine what law shall govern as to the condition and manner of payment. As a general rule, it is not necessary to the negotiability of the instrument that a place of payment be designated, but it is now required by statute in some of the states. The negotiable instruments law provides that the validity and negotiable character of an instrument are not affected by the fact that it does not specify the place where it is drawn or the place where it is payable. Section 51 must be payable in money. Another essential requisite of a bill of exchange or promissory note is that the medium of payment must be money, that is, the direction or promise in such instrument must be to pay in money. If the instrument calls for the payment of goods, or is in the alternative, as for the payment of a sum of money or to issue stock, it is not negotiable and becomes a mere simple contract. So if the instrument be expressed to be payable in work, or in any other article than money, as, for instance, an ounce of gold, it becomes a special contract, and by the law merchant loses its character as commercial paper. Thus it has been held that if the instrument be to pay money, and also to deliver up horses and a wharf, or to pay money and take up a certain outstanding note, it is not a negotiable note. But it is held that an unqualified order or promise to pay is unconditional though coupled with a statement of the transaction which gives rise to the instrument. So also an instrument in terms and form, a negotiable promissory note, does not lose that character because it recites that the maker has deposited collateral security for its payment, which he agrees may be sold in a specified manner. Thus it seems well settled that, although it may appear on the face of the note that its payment is secured by collaterals in personal property, or mortgage of real property, yet if otherwise in proper form, it is negotiable. The negotiable instruments law covers this and many similar provisions by the following section. An instrument which contains an order or promise to do any act in addition to the payment of money is not negotiable. But the negotiable character of an instrument otherwise negotiable is not affected by a provision which, 1. authorizes the sale of collateral securities in case the instrument be not paid at maturity, or, 2. authorizes a confession of judgment if the instrument be not paid at maturity, or, 3. waives the benefit of any law intended for the advantage or protection of the obligor, or, 4. gives the holder an election to require something to be done in lieu of payment of money. But nothing in this section shall validate any provision or stipulation otherwise illegal. It is uniformly held that a power of attorney to confess judgment must be strictly construed, and whether the power can be executed for the benefit of a holder of a note other than the payee must depend upon the language of the power itself. If the note is in itself perfect, without conditions, it may remain negotiable, although the power of the attorney to confess judgment may not, by its terms, operate in favor of an endorsee or transferee of the note. The validity and negotiable character of an instrument are not affected by the fact that it does not specify the value given, or that any value has been given therefor. But nothing in this section shall alter or repeal any statute requiring in certain cases the nature of the consideration to be stated in the instrument. Thus it is often required when notes are given for a patent or some right therein that the instrument should state the nature of the consideration. A promissory note or other negotiable invender at and sell any inventions wholly or part instrument, the consideration of which consists wholly or partly of the right to make, use or sell any invention claimed or represented by the vendor at the time of sale to be patented, must contain the words, given for a patent right, prominently and legibly written or printed on the face of such note or instrument above the signature thereto, and such note or instrument in the hands of any purchaser or holder is subject to the same defenses as in the hands of the original holder. But this section does not apply to a negotiable instrument given solely for the purchase price or the use of a patented article. The term money properly includes all legal tender. Though the word currency includes banknotes, which are not legal tender, yet it is held that certificates of deposit, notes, bills, bonds, checks and the like, payable in currency, or in current funds of this state, current Ohio banknotes, etc., constitute good commercial paper, and are really payable in money, as the term used is but a common expression used to indicate current legal tender. The property of being legal tender is not necessarily inherent in money, it generally belongs no more to inferior coin than to paper money. Legal tender is that kind of money which the law compels a creditor to accept in payment of his debt, when tendered by the debtor in the right amount. Foreign gold or silver coins are not legal tender. The gold and silver coins of the United States and United States notes are lawful money and legal tender in the payment of all debts, public and private. The validity and negotiable character of an instrument are not affected by the fact that it designates a particular kind of current money in which payment is to be made. But if the instrument is made payable in the paper or currency of a particular bank, specifically and absolutely, and without reference to the currency or value of the paper, it is held not to be for the payment of money and is not negotiable. It has been held that it is necessary that the instrument should express the specific denomination of money when it is payable in the money of a foreign country, in order that the courts may be able to ascertain its equivalent value. Otherwise it is not negotiable. Where an instrument is made payable generally in the money of a foreign country, without specifying the kind or denomination of the coin or money, so that payment may be made in our own coin of equivalent value as determined by the power of exchange, it is not negotiable, according to a leading case in New York upon this question. This is not the invariable rule, for in a Michigan case a note payable in Canada currency was held negotiable, and the New York case already referred to was disapproved. Section 52. Must be necessary parties. The name of the maker of a note or the drawee of a bill should appear on the instrument. In the case of the note it is important, as it is the maker who is liable thereon, and in case of the bill the drawee's name must be written in order to bind the party accepting. The bill must be addressed to some person, except that, a. If the drawee can be otherwise sufficiently identified from the bill it is sufficient, and, b. An unaddressed bill accepted or a bill accepted, where the drawer and acceptor are one and the same person, probably is to be treated as a promissory note, and is negotiable. The bill or note must point out some person to whom the money is to be paid. The following are the common rules concerning the nomination of payees. A. The payee of an instrument, except one payable to bearer, must be a person in being, natural or legal, and ascertained, at the time of issue. B. Where the payee and maker or drawer are the same person, the instrument is not issued until after its endorsement and delivery. C. The payee may be a fictitious or non-existing person, but the instrument is then construed as payable to bearer, and title thereto is made by estoppel. A bill may be addressed to two or more drawees jointly, whether they are partners or not, but not to two or more drawees in the alternative or in succession. Where in a bill the drawer and drawee are the same person, or where the drawee is a fictitious person, or a person not having capacity to contract, the holder may treat the instrument, at his option, either as a bill of exchange or a promissory note. The drawer of a bill and any endorser may insert thereon the name of a person to whom the holder may resort in case of need, that is to say, in case the bill is dishonored by non-acceptance or non-payment. Such person is called the referee in case of need. It is in the option of the holder to resort to the referee in case of need or not as he may see fit. A bill or note may be executed by one person or by a number of persons. When executed by but one, it is called a several note. When executed by two or more, it is either joint, or joint and several, according to its wording. Thus, if in a note signed by two or more, the plural number is used in referring to them as we promise to pay, it is held to be a joint note. While if in the same note the singular number is used, as I promise to pay, then the note is considered as joint and several, since this expression indicates an intention to make it a joint and several note. So the expression, we or either of us, is held to make a note joint and several. Section 53. The delivery. By the negotiable instruments law, delivery means transfer of possession, actual or constructive, from one person to another. An undelivered bill or note is inoperative, because delivery is essential to the final completion of every written contract. Until delivery, the contract is revocable. Delivery means transfer of possession with intent to transfer title, and is of two kinds. 1. The manual passing of the instrument itself, and 2. Some act manifesting intent to transfer right of possession while the possession of the instrument is actually with another. Where an instrument has not been delivered, it will not, if completed and negotiated, without authority, be a valid contract in the hands of any holder, as against any person whose signature was placed thereon before delivery. Every contract on a negotiable instrument is incomplete and revocable until delivery of the instrument for the purpose of giving effect thereto. As between immediate parties, and as regards a remote party other than a holder in due course, the delivery, in order to be effectual, must be made either by or under the authority of the party making, drawing, accepting, or endorsing, as the case may be, and in such case the delivery may be shown to have been conditional, or for a special purpose only, and not for the purpose of transferring the property in the instrument. But where the instrument is in the hands of a holder in due course, a valid delivery thereof by all parties prior to him so as to make them liable to him is conclusively presumed. And where the instrument is no longer in the possession of a party whose signature appears thereon, a valid and intentional delivery by him is presumed until the contrary is proved. By depositing a note in the mail with the intent that it shall be transmitted to the payee in the usual way, the maker parts with his dominion and control over it, and the delivery is, in legal contemplation, completed. Section 54. Value received. Value received is not necessary to be expressed in a negotiable instrument. Although these words are well nigh universal in negotiable bills and notes, they are in no wise necessary to them. Their omission is unimportant, because the negotiable instrument itself imports a consideration. The validity and negotiable character of an instrument are not affected by the fact that it does not specify the value given, or that any value has been given therefor. Section 55. As to the agreement controlling the operation. There are two kinds of agreements which control the operation of bills and notes, which are designated as a memoranda on the face or back of the instrument and collateral or independent agreements. The advantage of having a memorandum on the bill or note is that it will furnish actual or constructive notice to all subsequent holders, whereby it will control the operation or character of the instrument, whereas a collateral agreement can only control the operation or character of the instrument as to those parties who have received actual notice of its existence. Only such memorandum as does actually affect the character and control the operation of the instrument will be considered to be a part of the bill or note. Nor can the memorandum be treated as a part of the bill or note where it is so ambiguous and repugnant to the other contents that parole evidence is necessary to explain its import, or where the agreement is repugnant to the assignment or transfer of the instrument. Where the memorandum is added to the bill or note after its negotiation, with the consent of both parties, it will constitute a part of the instrument, controlling its operation, but if it is added without the consent of all the parties, it will be an alteration which will invalidate the bill or note. Collateral agreements entered into contemporaneously with the execution and negotiation of the instrument must be in writing in order to be valid and control the operation of such bill or note. Subsequent agreements which change the terms of bills and notes already delivered must be based upon a sufficient consideration and be fully executed or performed in order to control the operation of the instrument as to all parties who have notice of the collateral agreement. The most common collateral agreement is that of renewing the bill or note. If the renewal is contemporaneous with the instrument, it must be in writing, and if subsequent, it must be supported by a sufficient consideration. A note which contains a statement to the effect that the maker has deposited collateral security for its payment does not thereby lose its character of negotiability, nor does the fact that a note is received with collaterals affect such negotiability. Section 56. Days of Grace. As to days of grace, the negotiable instruments law provides, Every negotiable instrument is payable at the time fixed therein without grace. Where such law is not in force, grace is a short period of time, extended by the written law to instruments not payable on demand, to enable the parties to provide payment. It arose before the age of steam, when communication was slow and often difficult. It is said to have been a mere matter of indulgence at first, at the holder's election. The rule is peculiar to the law merchant, and since the reason for it has mostly ceased, it has been abolished by statute in most jurisdictions. Days of grace are days added to the nominal time of payment of all bills or notes except those impliedly or expressly payable on demand, and are computed by excluding the day of date and including the day of payment. When granted at all, they are usually for 3 days. But as stated above, days of grace have been abolished by statute in many jurisdictions. Section 57. As to stamps, it seems that the first stamp duties were those levied by Holland in 1624 for the purpose of raising revenues for the prosecution of war against Spain. The first stamp duties levied in England were in 1694 and were employed to wage war against France. Some of the states of the Union have at different periods passed an act imposing stamp duties on certain negotiable instruments. The first act of a similar nature passed by the federal government was in 1862 during the War of the Rebellion. This act imposed a tax upon deeds, bills, notes, checks and other evidences of indebtedness. This act was subsequently repealed, from which time no stamp duties on these instruments were required until 1898, when the War Revenue Act was passed. This act imposed a stamp tax upon bills of exchange, promissory notes, money orders, certificates of deposit, warehouse receipts, bills of lading and other evidences of indebtedness. In 1901 this act was repealed except as to bills of exchange, and in 1902 it was repealed as to these. Section 58. As to blanks, frequently bills of exchange and promissory notes are executed in blank and delivered to another to fill in and negotiate, either for his own benefit or that of the maker. The person to whom these instruments are delivered in blank with authority to fill the blanks is constituted the agent of the maker or principal. There is no need of a second delivery by the maker after the blanks have been filled, because the validity of the paper after its completion will relate back to the delivery by the maker or drawer. It may be, however, that the authority of the person to whom the instrument is delivered is limited to filling the blanks in a particular way, and in such case, if he exceeds his express authority, of course neither he nor any holder, with knowledge that the authority has been exceeded, can recover. But anyone purchasing the instrument as filled in reliance upon its terms, would be protected. Moreover, a bona fide purchaser is protected, and may enforce the instrument as filled in even if he had knowledge that the instrument had been delivered in its imperfect state, for he may rely upon the apparent authority of the person to whom it was delivered to fill in the blanks as he sees fit, and as against such a holder the fact that the actual authority was exceeded is no defense. The negotiable instruments law states, where the instrument is wanting in any material particular, the person in possession thereof has a prima facie authority to complete it by filling up the blanks therein, and a signature on a blank paper delivered by the person making the signature in order that the paper may be converted into a negotiable instrument operates as a prima facie authority to fill it up as such for any amount. In order, however, that any such instrument when completed may be enforced against any person who became a party thereto prior to its completion, it must be filled up strictly in accordance with the authority given and within a reasonable time. But if any such instrument, after completion, is negotiated to a holder in due course, it is valid and effectual for all purposes in his hands, and he may enforce it as if it had been filled up strictly in accordance with the authority given and within a reasonable time. Section 59. As to instruments bearing a seal, the mere attaching a seal to the instrument does not necessarily make it a sealed instrument. In addition to this, there must be some reference in the instrument itself to the seal to bring it within the purview of sealed instruments. The validity and negotiable character of an instrument are not affected by the fact that it bears a seal. Section 60. The several parts of a foreign bill called a set. The following is a common form of foreign bill of exchange in a set. Troy, N. Y. U. S. A. August 31, 1908. First exchange for London. 30 days after sight of the first of exchange. Second and third unpaid. Pay to the order of John Bales £300 sterling. Value received and charge the same to account of Orne and Barker. To Green and Co., London, Eng. Troy, N. Y. U. S. A. August 31, 1908. Second exchange for London. 30 days after sight of this second of exchange. First and third unpaid. Pay to the order of John Bales £300 sterling. Value received, and charge the same to account of Orne and Barker. To Green and Co., London, Eng. Troy, N. Y. U. S. A. August 31, 1908. Third exchange for London. 30 days after sight of this third of exchange. First and second unpaid. Pay to the order of John Bales £300 sterling. Value received, and charge the same to account of Orne and Barker. To Green and Co., London, Eng. In order to avoid delay and inconvenience which may result from the loss or miscarriage of a foreign bill, it is a common custom, particularly in bills drawn on Europe and other distant countries, for the drawer to issue several copies of the bill as above, which are called a set of exchange, and together constitute one bill. Where a bill is drawn in a set, each part of the set being numbered and containing a reference to the other parts, the whole of the parts constitute one bill. Either copy of the bill may be negotiated, and when any one of them is accepted and paid, all others are extinguished, even against bona fide purchasers, so far as the drawer is concerned, although the payee is liable to each person, to whom he has transferred a copy of the bill. The drawer should accept only one of the copies, and pay the amount of the bill, when the part which he has accepted is presented for payment. If he accepts more than one copy, he will be liable to bona fide purchasers on as many copies on which he has written his acceptance, but any copy may be presented for acceptance, and the drawee may accept any copy. Where two or more parts of a set are negotiated to different holders in due course, the holder whose title first accrues is as between such holders the true owner of the bill. But nothing in this section affects the rights of a person who in due course accepts or pays the part first presented to him. Where the holder of a set endorses two or more parts to different persons, he is liable on every such part, and every endorser subsequent to him is liable on the part he has himself endorsed as if such parts were separate bills. The acceptance may be written on any part, and it must be written on one part only. If the drawee accepts more than one part, and such accepted parts are negotiated to different holders in due course, he is liable on every such part as if it were a separate bill. When the acceptor of a bill drawn in a set pays it without requiring the part bearing his acceptance to be delivered up to him, and that part at maturity is outstanding in the hands of a holder in due course, he is liable to the holder thereon, except as herein otherwise provided, where any one part of a bill drawn in a set is discharged by payment or otherwise the whole bill is discharged.